today's discussion is historical evolution of citizenship laws in post-colonial world. But I've taken some liberty to discuss on constitutionality of the Citizenship Amendment Act also. I've inquired that if anyone is speaking from the resource person. I was told that no one is speaking. So I thought that I should discuss something on that. So I tried to know what is post-colonial. I am a pure law student. Being a 3-year law student, that too from science background, we are never taught, never trained in sociology. So post-colonial type words have always troubled me very much. I've gone through some meaning, some encyclopedia that gives me 2-3 meaning. One suggests that so far as time is concerned, this is some activity that is maybe when we were colonized, post-colonizers. We were the slaves of the English. So once we became freedom, all areas, all era that become post-colonial era. Other experts suggest that it is all development in the colonial jurisdiction, pre-colonial jurisdiction, all development after 50s, 60s or 70s. There is another meaning that is critical academic study of the cultural, political, economic legacy of colonialism and imperialism, focusing on the impact of human control and exploitation of colonized people and their lives. So it does believe that colonialism is not something that has gone. It is a type of maybe mindset. So therefore there may be one form of colonialism had gone, but another form of colonialism may come. So this was a difficult terrain for me. Just for some brief understanding, I tried to find what is post-colonialism. And I understand that the legal developments in the area of citizenship law, I have to probably discuss this. Now, what is citizenship that we all know? It is a relationship between individual and state. But this relationship is a two-way traffic. First, that individual must have allegiance to the country, which is non-compromising. Criticism is one thing, but allegiance is something which is non-compromising. An unquestionable allegiance too. And then a person is entitled to its protection. If you lose allegiance, you lose protection. So this is complementary to each other. We cannot say that our conduct, our speech is secessionist or seditious in nature or shows something which is closer to disaffection, and then again we keep on getting all type of protections. So both cannot go together. Allegiance of the citizen, and it is followed by protection from the state. Now there are two principles that deal with citizenship. One is just solely, that says citizenship is by place of birth. It is the liberal type of thing. So, as for example, USA, you get birth in USA, you automatically become the citizen of USA. Automatically. Your parents, who are your parents, where are they, what are they doing, that hardly matters. And this has become more relevant because in the election campaign going on for presidency, one of the candidates, Trump, has said, I'm going to change it. I'm going to change this just solely citizenship by place of birth. No. It is a type of maybe birth tourism. So pregnant ladies, when they become pregnant, they visit USA, child is born, and they go, the child becomes US citizen, and because child becomes US citizen, automatically you also get, because your mother or father, you get some rights. And it is creating many problems like maybe illegal immigrants. So I'm going to change it. This is a part of Agenda 47. And Trump said, once I win, the next day I'm going to do this. Second is just sanguinis. Just sanguinis, recognition to blood ties. That it is not by birth I became citizen. I must have some blood ties. So my parent must be a citizen of that particular country. These type of both the things are prevalent. Now, just solely US recognized it through 14th Amendment, but it has a story that we will discuss. And I told you 2024, this has become very much relevant. Now, when we talk about citizenship or any legal development, USA is one example, ideal example. Because USA is supposed to be a very liberal country. It had the first written constitution, 1787. It was ready 1789. It was signed 1791. First 10 amendments came in. Now, in the original constitution in 1787, when the constitution was ready, there was no provision for fundamental right. US was a colonized country, 13 colonies. Britain has enslaved them. They had the previous experience of what colony means. So when the constitution is made, that means there had to be some discussion on rights. Unfortunately, there was no discussion on right. The constitution was made, only rules of governance were given, no fundamental right. Why no fundamental right? Because many people who were the father of that constitution in the making process, like Madison, Jefferson, and John Jay, they were initially very happy that okay, now constitution will be made and we will be free and freedom and liberty and equality will come and we all will be equal. When he said we all will be equal, he had in mind all whites will be equal. And then somebody told him, you know what is the meaning of equality? Equality does mean equal citizenship, does mean black and white will be equal. Master and servant will be equal. Slave and owner will be equal. Are you ready for this? And then the makers of the constitution said, oh my God, what do you mean? Whether I and the black and slave and I the master will dine together, move together, sit together? But yes, that is the meaning of equality. They said equality is a dangerous idea. Therefore, the US Constitution did not contain the fundamental rights initially. But then other states, they were uncomfortable with this idea. They wanted their freedom, their rights to be protected. And then in 1789, they signed the document on the promise that fundamental rights will be incorporated. And then 1791, first 10 amendments came in the USA Constitution. But then when first 10 amendments came in, you would again be surprised to know equality was not among first 10. Freedom of speech was there. Right to religion was there. Not equality. Why? Because it was not very comfortable idea. And therefore, they were not ready to accept it. That all will be equal citizens. Male and female. What to talk about black and whites? Male and female will be equal citizens. They were not comfortable with this idea. Then in 1857, two historical events took place. One in India and one in USA. And both dealt with freedom. We all know what happened in 1857 in India. We are trying to revolt against the English. But in 1857 in USA also, there was one person black, that is Dred Scott. He was a slave. So slavery was permissible. In USA, some of the states slavery was permissible. आप खरीद बेच सकते थे. किसी को पैसे देकर आप किसी व्यक्ति को खरीद भी सकते थे. कुछ स्टेट्स में स्लेवरी परमिसिबल थी, कुछ स्टेट में स्लेवरी परमिसिबल नहीं थी. ड्रेड स्कॉट वाज परचेस्ड in 1940, 42, 43, and his master, He was in army, so he had to go to many places. So initially he was in one place where slavery was permissible. Then he went to some other place where slavery was illegal, not permissible. So he argued that from the place where slavery is permissible, I had come to a place where slavery is not permissible. So now I am a free person because the local law prevails. And in this area, slavery is not permissible. I am no more slave. So please give me my freedom. Please give me my freedom. Because in this state, slavery is not permissible. This matter ultimately went to the Supreme Court. US Supreme Court. The great US Supreme Court. And what did the court decide? By 7:2. 9 judges always sit in the US Supreme Court. 9 judges are there. 9 judges decide every case in USA. 7:2, they decided African Americans were not and could never be citizens of the US. जो अफ्रीकन अमेरिकन है वो कभी भी नागरिक बन ही नहीं सकते. And another thing was that if the parliament want to remove slavery, parliament cannot do it. This was the judgment of the US. This is the struggle for citizenship. Struggle for citizenship. Then that led to various discontent, and ultimately in 1865, 13th Amendment came in and slavery was removed. So now the slave can be thought of that he can be a citizen, US citizen. 1868, 14th Amendment came in, that right to equality was recognized in 1848. See, the Constitution was ready in 1787. Fundamental rights were incorporated in 1791. But right to equality found a place in the USA Constitution in 14th Amendment because the framers of the Constitution were not comfortable with the idea that citizenship means everybody would be equal. Ultimately, in 1868, the 14th Amendment came in. But then everything was not fine. We know what happened in Plessy versus Ferguson. In Plessy versus Ferguson, there were two coaches. One coach was for black, other coach was for white. Blacks citizen could not go in the white's coach. So they approached the Supreme Court and they said, this is not equality. We want to go and sit in the white's coach, but we cannot sit. Then the judge said, you tell me, what is the fare? Whether the fare in the white coach and black coach are the same? Well, yes, sir, they are same. Whether the furnitures are same? Well, yes, sir, furnitures are same. Whether the window is same? Yes, windows are same. Whether doors are same? Well, yes, doors are same. Then the Supreme Court said, then what is the problem? You have given equality. Equal fare. Equal window. Same quality furniture. Why do you want to go in the whites? Why do you want to go sit with the whites? This was Supreme Court decided when even Article Amendment 14 was brought in. Right to equality was brought in. It was in 1896. The Supreme Court again unfortunately decided that no, even if they have become equal citizen, equality means equality for formal purpose, not substantive equality. And then ultimately in Brown versus Board of Education, this equality doctrine was established 4 years after our constitution came into existence. Let us see how the citizenship dealt with male versus female in USA. Once they got free, colony means once you are free from colony, how the development took place. So I discussed that 1868 14th Amendment came in. Equal protection clause was incorporated. That means male and female are equal now. Male and female are equal. They are equal citizen. But no. In Minor versus Happersett, 1875, the US Supreme Court decided that even if there is a 14th Amendment, equal right to woman is not protected under right to equality. Women is not equal citizen vis-a-vis male. And state can discriminate. State can say in this room, males who give vote and females cannot give vote. And the Supreme Court said, no, no, this is permissible. This is permissible. One of the reasons in the mind was that male is a superior race. They are more intelligent than the female. It was in 1875. Then in 1878, in order to remove this citizenship discrimination, an amendment was brought in. But it was defeated ultimately in 1920 through 20th Amendment. 19th Amendment, the right to equality was right to equal citizenship to women was given. There was problem in UK, but I am skipping that part and coming to India. So, Government of India Act 1935, it had given certain rights to state legislature, but it has banned any state legislature to discuss on citizenship. Ultimately, it was repealed in Indian Evidence Act 1947. Then the Pakistan Control Ordinance 1948 was passed. The whole purpose was to give permit to whosoever is coming from Pakistan to India or India to Pakistan. So that permit was also a type of recognition of citizenship. Then Abducted Persons Recovery and Restoration Act 1949 came in. The whole purpose was that those people who were abducted during riots, Direct Action Day, mainly they were women, if they are found in India, the government will take possession of those ladies and they will be sent back to Pakistan to their families, and same was expected from Pakistan. So that was another type of recognition so far as identity and citizenship is concerned. Then in 1949, Part 2 of the Constitution of India, that is Citizenship, Chapter 2, Part 2, came into force. In 1955, Citizenship Act 1955 came in. Rules were framed in 1956. Various amendments were brought in 1962, 1986, 1992, 2003, 2005, 2015, 2019, and rules were notified in 2024. I'm not going in the citizenship. I will just come directly to what is the issue in the Citizenship Amendment Act 2019. The first point is, Constitution has not been amended. There are various confusion that Constitution has been amended. Constitution has not been amended. 2019. It is the law, that is Citizenship Act was amended. See, it is known as Citizenship Amendment Act 2019. And the objective that is given in the objective clause is that the Parliament says that trans-border migration of population is historical between India, Bangladesh and Pakistan. There is specific state religion, so Afghanistan, Pakistan and Bangladesh are specific state religion. Persecution of minorities, that includes forced conversion, ethnic cleansing, religious freedom. These three words are not mentioned in the enactment that I am adding. So persecution of minorities are going on in these three states, and these people have come to India, staying in India for a longer period. Who are these people? The 6 groups of people: Buddhist, Parsi, Jain, Sikh, Hindu and Christian. They are minorities in Afghanistan, Pakistan and Bangladesh. So 3 states, Afghanistan, Bangladesh and Pakistan. If any of these 6 people have come to India and they are living here for last 5 years, the deadline is 31st December 2014, about which Professor Manoj Sinha sir was discussing that why 31st December 2014. If they are staying for last 5 years, then their procedure to get citizenship will be fast forwarded. Fast forwarded means anyone can get citizenship of India following various procedure which is mentioned in Citizenship Act and the Constitution. And the procedure is that he will have to stay in our country for 11 years. These 6 groups, they have to stay for 5 years. That is the only difference that has been made. But there is great confusion in this. Confusion is that as if a Muslim, he wants to come from Pakistan, he cannot become citizen. That is completely wrong. Anybody can come to India, be it Pakistani Muslim or from a China Muslim or from Afghanistan Muslim or a Sri Lanka Muslim or a Christian from any country can come to India, follow the procedure, had to stay for 11 years, he can get citizenship subject to the rules and regulations. These six group of people, they have to stay for 5 years. That is the only difference. There is no blockage. No one has been stopped becoming citizen of India, and that is this confusion should not be there. So I told you that there is normal procedure, there is a fast forward procedure. Normal procedure, Constitution and Citizenship Act is applicable for any foreigner. They can become citizen of any religion, any faith, of any state, under certain conditions, and the requirement is that they have to stay in India for 11 years. These six groups who are persecuted, they have to stay here for 5 years, and then they can get citizenship. Now, finally, this law, what is the constitutionality involved in this? So any question, any such question, any law had to face three types of questions. One is desirability, other is constitutionality, and third is feasibility. Feasibility comes when you start implementing. Without implementation, you cannot know the feasibility. Constitutionality is a pure legal question, and desirability is a pure political question. So this law is challenged in the Supreme Court. There are mainly three grounds. One is that it violates fundamental rights, Article 14, 15, 21, and 25. Second is it violates other enforceable provision. And third is it violates certain principles like basic structure theory, secularism, and equality. Now, the point is that whether minority and majority can be two distinct groups or not. Can minority be a group and can majority be a group? In our constitution itself, minority as a group has been recognized. They are given special rights. So minority and majority is a group which is recognized not only in India, not only in USA, all over the world. So two groups can be there. They can be in India, they can be in foreign country. So two distinct groups can be created. If you remember Chiranjit Lal case, in that case it was held that even one person can be a separate class. Even one person can be a separate class. In this case, there are three groups. Even if the government takes one person, that can be a separate class, according to Chiranjit Lal case. Now, second point is that three states have been taken. Three states are Muslim majority states. So, why other states have not been, for example, Myanmar, China, Sri Lanka, these states have not been taken. So certainly it is a valid question. It is not a legal question. It is a political question again. It is not a legal question why this state has been. This cannot be litigated. This can be asked in the parliament, but not in a court of law. Why only three states? So, is the ground religion? The discrimination ground is religion? No, religion is not the ground. It is a religious persecution. Government itself, this document says it is the religious persecution that is the ground for discrimination. Let me discuss with you 2-3 cases and then I will wind up. State of Jammu and Kashmir, Triloknath Khosa case, 1974, the Supreme Court said that we cannot sit in appeal over the legislative judgment with a view to finding out whether on comparative evolution of rival theories, other inclusion exclusion can be better. It is not the job of the court to make a comparison. Legislature has made this, why not this? This is not the job of judiciary. That question can be asked in the parliament. Parliament has passed the law. If the people feel that the parliament is not done, then the next 5 years when the election will come, they will throw them out. But that question cannot be litigated in the court of law. So state of Jammu and Kashmir, Triloknath, but it is to take care this case on employment, not on citizenship. Then burden of proof here on petitioner, that classification was unreasonable. That the classification between minority community in Pakistan, Bangladesh and Afghanistan and majority community, This classification does not exist. This you have to establish. And we have no rational access. Ramkrish Dalmia case 1958, another constitution bench case. It has 3, 4, 5 pointers which can serve as a beacon when you discuss the constitutionality of this case. First is that there is always a presumption in favor of the constitutionality of an enactment, and the burden is upon whom, which I have already discussed. The second is, it must be presumed that legislature understands and correctly appreciates the need of its own people. See, it is presumed, the court says that we presume that the legislature understands and correctly appreciates the need of its own people, that its laws are directed to problems made manifest by experience. And third is that the legislature is free to recognize the degree of harm and may confine its restrictions to those cases where the need is deemed to be clearest. Two more points, and these are the final 2 points. That in order to sustain the presumption of constitutionality, the court may take into consideration matters of common knowledge, matters of common report, history of the times. So history can be taken care of, and may assume every state of facts which can be conceived existing at the time of legislation. But finally, there is a caution that while good faith and knowledge of the existing conditions on the part of the legislature are to be presumed, if there is nothing on the face of the law or the surrounding circumstances brought to the notice of the court on which classification may reasonably be regarded as based, the presumption of constitutionality cannot be carried to the extent of always holding that there must be some undisclosed and uncommon reasons. So that is the warning to the government, that you cannot keep on resorting that there is some reason which we cannot disclose. You have to disclose some reason, and in the objective clause itself, the reasons have been disclosed. Lastly, I will close this with the USA case of Trump versus Hawaii. In 2018, this case was decided. What happened in this case when in 2018, Donald Trump won the election? The very next day, what he did, he passed an executive order. In that executive order, he required that in order to combat the menace of terrorism, every state will be required to give them information about anyone who is coming to their land. So most of the countries have provided them the information, whatever information they sought, where they belong, what is their identity, what they do, what is their profession, the normal information which is available. There were 7 countries, Iran, Iraq, Libya, Somalia, Sudan, Syria, and Yemen. They said that we are not going to give any information. It was a matter of chance that all countries were 7 Muslim countries. So an entry ban was executed that people from this country cannot enter USA land. This executive order was challenged in the Supreme Court because the First Amendment says that right to religion is a fundamental right. There is equality of religion, and it was argued that 7 Muslim countries were discriminated, and that violates First Amendment of the Constitution. The Supreme Court, the very liberal Supreme Court, in a very thin majority, 5-4, declared that this executive order is valid. Number 1, that this executive order is valid. That means executive order can discriminate citizens who may by chance belong to particular religion. But this discrimination is a valid discrimination. This is one. Secondly, the court said that entry of foreign nationals is a matter of sovereign jurisdiction. हमारी कंट्री में कौन सिटीजन बनेगा, कौन सिटीजन नहीं बनेगा, एंट्री कौन करेगा, नहीं करेगा, ये कोर्ट कैसे डिसाइड करेगी? ये तो इट इज अ मैटर ऑफ सोवरेन जुरिस्डिक्शन. Court cannot decide. It can be decided in the parliament through law, but courts are no one to decide. No one else can decide. It is the government and it is the parliament can finally decide. Why? Because the government knows better than anyone with which country to make what. So this is the last significant point I want to make. So based on this idea, I would see that the Citizenship Amendment Act, though prima facie seems to be discriminatory, is indeed not discriminatory, and the parliament has every right to make this type of big discriminatory treatment on the ground of religious persecution.